You're recognized, Senator.
Thank you, Mr. Chairman. Thank you, members of the committee. I'm here to present Senate Bill 959. Some of you may be familiar with the bill. In short, it does two things. It deals specifically with the issue of adoption and placement in foster homes, and it places two restrictions on who can be eligible to be an adoptive parent or a foster parent under our state law. The first restriction is that it would apply specifically to homosexuals. The second restriction is that it applies specifically to cohabitating couples, which is defined as being involved in a physical relationship and residing together. There is an exception under both foster care and adoptive placement for relatives of the child for the cohabitating couple section. Those exceptions with respect to the relationship to the child are for siblings, step-parents, grandparents, great-grandparents, or any other unmarried adult who is either related by blood or marriage to the child, has demonstrated the ability to care for the child, or is otherwise eligible to be a foster parent for the child or adoptive parent for the child. There's been a lot of misinformation on both what the bill does and on what the law is. The bill does not in any way restrict who can have custody of a child. It does not in any way affect a natural parent who falls into one of these categories from maintaining custody of the child. It does not affect guardianship of the child. We were told the other day that this bill would say that you can't decide who would take care of your kids when you die. The way you do that is through your will by a guardianship provision. This does not in any way affect guardianship. There has been a lot of discussion on what is legal and what's not legal, what's constitutional and what's not constitutional. The best way I know to address that is to look at what the court actually said. The reason that we are here addressing this issue now is because the Arkansas Supreme Court in the Howard case last year struck down a provision, a rule, a regulation that had been adopted by an executive branch agency. When they struck that down, it was challenged on a number of grounds. One of those was separation of powers. One of those was the right to equal protection. One of those was the right to privacy right to association. The Arkansas Court of the Trial Court specifically ruled this does not violate equal protection of either the U.S. or the Arkansas Constitution, does not violate equal protection, right to privacy right to association as it pertains to either the U.S. or the Arkansas Constitution. They struck it down specifically and only on the basis of separation of power. Now you will be told that there were findings of fact that there was no evidence put on to show that there was an issue of public health related to this. And that's correct. There were findings of fact that were made by the trial court and they were recognized by the Supreme Court. They did not go to the issue of whether or not this was constitutional on its face, though. They went specifically to the issue of what authority was delegated to this executive branch agency by the legislature. The court ruled that this was a separation of powers violation and that this was a legislative function that had been usurped by an executive branch agency that did not have the authority to do so. You'll be told that this was struck down because there was an element of morality that was built into the decision-making process to adopt the rule. And that is correct. But it's not because we can't make laws that have some element of morality as the basis. It's because the limited scope of power which was given to the Child Welfare Agency Review Board did not include that. The ACLU and other folks have mentioned that if this bill passes, it'll clearly lose on the challenge because you can't specify a group, in this case homosexuals, to restrict on the issue of adoptive or foster parent. Well, the highest federal court that we have that has addressed the issue says otherwise. Florida has an outright ban, and I will read the language in the Florida statute to you, and it has been challenged at least 3 times and upheld each time. The Florida statute says, and I quote, "No person eligible to adopt otherwise under this statute may adopt if that person is a homosexual." That has been challenged most recently in 2004 in the Lofton case. That was appealed to the 11th Circuit Court of Appeals, The 11th Circuit upheld, for the third time now, upheld that statute. They ruled specifically in the 11th Circuit that this did not violate equal protection, did not violate right to privacy, did not violate intimate association. There was not a constitutional issue there. The U.S. Supreme Court denied cert, let the case stand. To my knowledge, there is no other federal court of the appellate level that has ruled on this in any contrary way. It has been raised that the Texas sodomy case, the Lawrence case, which struck down the Texas law on sodomy that dealt with the consensual relationship of adults, saying that that can't be regulated by the state, would be controlling in this matter. Specifically on that point, the 11th Circuit Court of Appeals said that Lawrence was not a controlling decision in this matter, and that the difference was that that regulated the relationship between two consenting adults, and this regulates the relationship between adults and children, where the state has a legitimate interest in protecting the best interests of the children. An argument has been made that we shouldn't do this because you're limiting the number of foster homes that are out there, and that there are children that need foster parents. I'll say that this has been the policy of the state for the last approximately 8 years with respect to foster care, and this doesn't do anything different with respect to the foster care side of things that we weren't already doing as a state through policy until last summer, from the standpoint of limiting homosexuals to be foster parents. But the issue of whether or not we had an interest in making sure that you had this vast scope of foster homes available for placement or adoptive homes available for placement, where that fit into the state's interest, the state ruled specifically that the Lofton Court ruled specifically that the state's interest is in protecting the best interests of the child and not in placing the child in the first available home. They said specifically that the interest of the state is to find the optimal home for the child. Lofton ruled, and I quote, "There is no fundamental right to adopt, nor any fundamental right to be adopted." They discussed at length the fact that adoption and foster parenting are both creatures of statute created by the state. They're not constitutional rights. With respect to whether or not it should be a constitutionally recognized right, the court specifically declined to do that and specifically declined to raise it to that status in the Lofton case. On the issue of privacy and whether or not we should be asking these types of questions, I want to point out that we ask a lot of questions when we examine somebody to be a foster parent or an adoptive parent. We look at their financial issues, make sure they're able to provide for a child. We look at their backgrounds. The court in Lofton said that the decision to adopt a child is not a private one, but a public act. In short, a person who seeks to adopt is asking the state to conduct an examination into his or her background and make a determination as to the best interest of the child in the need of adoption. In doing so, the state's overriding interest is not providing individuals the opportunity to become parents. And I want to repeat that because that seems to be a big part of the question here. In doing so, the state's overriding interest is not providing individuals with the opportunity to become parents, but rather identifying those individuals who it deems are most capable of parenting adoptive children and providing them with a secure, stable family environment. When seeking to adopt or provide foster care, an individual is asking the state to entrust into their permanent care, in this case in adoption permanent care, a child for whom the state is, in our case, acting in loco parentis. We have an obligation as public policymakers who are elected by the people of Arkansas to determine what the policy of this state will be. An executive branch agency usurped that authority by acting outside the scope of the power that we had delegated to them, and it was struck down. There will be a lot of arguments made today, but I hope that you understand, and I hope that it has been made clear that the arguments as to whether or not this is constitutional, in my opinion, and in the opinion of the 11th Circuit Court of Appeal and the trial court in the state of Arkansas, those issues are not in question. This is a valid exercise for the legislature to do. This is our role. It was not the Child Welfare Agency Review Board's role. And with that, Mr. Chairman, I would be happy to answer any questions. I appreciate a good vote.